first matter to come before us this morning is State of Ohio versus Kevin Banks. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time for rebuttal, if you let me know when you get started, keep the clock, and I can keep you apprised of the passage of time. We've read the briefs, we'll proceed when you are.
Thank you, Ron. I would like to reserve 5 minutes for rebuttal. Your Honors, representative from the state of Ohio. First of all, good morning. Thank you for the opportunity to argue on behalf of Mr. Banks. Your Honor, there's 3 assignments of error from the trial which he was found guilty of sentence. The first assignment of error deals with manifest weight. That we believe, Mr. Banks believes, that the evidence was insufficient to sustain the convictions as to count 1 and count 2. Specifically, Your Honor, the brief outlines in reverse with respect to count 2 of the indictment. The state failed to establish that he knew that an official proceeding or investigation was in progress or was about or likely to be instituted, and that his conduct was with the purpose to impair its value or availability. Frankly, Your Honor, it's Mr. Banks' position that there was nothing beyond just assuming he would have known that there was an investigation started. He walked out of the booth. He was pointed at. The record is clear, served 2 terms.
How about would likely to be instituted?
Well, Your Honor, frankly, and I understand it because those are one of the issues that I looked at. The problem is if he's in, from his testimony, he is in there. He admitted more than one booth that day. If he's in there and he's doing something that's completely legal, and he comes out and then he's pointed at and people come up to him, even if we believe that the store wanted to talk to him about something, even if we believe that they're saying, hey, how many items did you take in there? His response to that, his freaking out, for lack of a better term, even in that exchange, there's no crime there. There's no investigation there. If we go to Target, and by going to Target, someone says, hey, you can't take but 5 items in there, it's not a crime that would not institute an investigation. No one tries to stop him on the way out. His reactions seem to be clearly bizarre, seem to be, I think, consistent with a person who then testifies that they suffer from PTSD.
But counsel,
Yes, Your Honor.
what other reason would you cover your license plate with your T-shirt? 22 years on the bench, I've never heard of anybody even doing that. That's just amazing to me that you would even have the forethought to think of something like that.
Well,
Because I don't think there's any dispute as to the evidence that that's what happened, right?
I agree with that, Your Honor. What I would respond to that is, absolutely, in 22 years you haven't seen that. Absolutely, that seems to be outrageous and bizarre. And absolutely, Mr. Banks would argue, was consistent with a person who was suffering from something because of trauma that they experienced as far as the military goes. I think that it was so outrageous, it is consistent with what he ultimately testifies to in this.
But the point is, whether it's PTSD or not, which I don't take lightly, that's absolutely horrific. But the point is, we're looking at just whether he was covering up the license plate in order to impede an investigation.
Well, Your Honor, excuse me. Your Honor, if that's the case, there are 2 duplicate license plates on that vehicle. There was no evidence that suggested it did not comply with Ohio's law on licensing. If we are to believe he is being so smart and so quick thinking that he covers the back one, I think it also makes sense that we would extend that same knowledge, savvy, surreptitious behavior that he would have done both. The interesting thing is that 2 minutes after he leaves his parking lot, he's stopped by the police and there is nothing on his license plate. I don't believe that, that he in any way impaired the value or the availability of evidence in the proceeding or the investigation. So I think that part is void also in the transcripts. In regards to the count one, Your Honor, I think this is even more clear, more supportive, that Mr. Banks believes that they failed to establish essential elements for the purpose of sexually arousing and gratifying himself. They commit trespass, otherwise surreptitiously invade the privacy of another, a videotape. Obviously, our position is he testified to exactly what he was doing. There were booths available right beside the booth. This booth, and I don't think that there's any testimony in the record that suggests it differently, was over 5 feet away with a high wall. And
Directly across
yes,
from where the young lady was.
absolutely. And that the technology that we have on phones today is a mirror technology, so that you absolutely have the ability to be able to see yourself with cell phones, and that he testified to that that's what he was doing, and there doesn't appear to be any information that suggests that this was for the purpose of sexually arousing or gratifying himself. They did tests on napkins that were present. Those tests were negative for any semen or sperm.
Did they confiscate the phone and search the phone?
Absolutely, Your Honor. They confiscated the phone. The state, in its response, suggests that he could have, in that time period, erased and deleted all the information.
So no pictures whatsoever?
There were no pictures, which is consistent, because there were no pictures of him and his tattoo either, because he never alleges that he was doing that to take pictures of it. He was only seen with the various T-shirts, if you could actually still see the tattoo that he had. Argument is very simple, that I believe that it is today's technology suggests that even when things are removed and deleted from cell phones, there is a digital footprint that exists that the state of Ohio could have, and frankly, I believe probably did look to see if they could find the footprints on that. So it doesn't appear that if that was the purpose of it, there to be no video, there to be no pictures at all of any point during this time period. I think it's interesting because they don't allege that there's any pictures of any time even surrounding this. If he gets there at 2 or 2:30, there's no pictures of anything well before that. Nothing that would suggest that. And because the record is devoid of those things, it's not clear to me where the evidence is that shows either one of those things. I not only do I think it's not sufficient, I think it's void. The record is void of that information.
Was there anything, I don't remember from the briefs, was there any discussion, not discussion, but any testimony in regard to whether or not those were unisex dressing rooms? Because usually they have male and female.
Your Honor, what I do know is that there was an area in which the first time he went in, which I think is important because obviously pertains from the men's section, and he went in to the closest one in that section. When he tried everything on it and left, he was unable to use the ones that there because they were full, so he went to the next one. So, and I think that probably the record should have been pounded that he went in twice. His conduct showed he was trying on clothes. There's nothing in here, no testimony that seemed to show that he was shopping around for what booth that he would go into.
Well, I thought there was actually testimony that the young girl said that she had gone into a couple different try-on areas and had finally settled on one particular one, like the second or third one down, and he actually was moving with her to different places.
Your Honor, I would suggest that his conduct, he went in twice, and that he never suggests that his conduct was anything other than to try on. And the amazing thing is, if that would be the case, the evidence of, if he's following her around, why would there be no pictures? That's
Well,
what
he
I'm
could
saying.
have deleted them, that's what the prosecutor's saying, he could have deleted them. I understand you're saying that maybe they could have retrieved them, I don't know whether they could have or not, but we can only go by what's in the record, and there's nothing in the record either way, right?
I would absolutely agree with it.
And you're just now reaching that 5 minutes of time.
Thank you.
Good morning, Your Honors. My name is Vince Vellucci. I am an assistant prosecuting attorney with the Medina County Prosecutor's Office for the state of Ohio. I will start with Mr. Banks's first assignment of error, the sufficiency challenge, and it's actually combined with a manifest weight challenge. I'll actually start with the first count, the voyeurism. I'll start with the first argument that has to do with finding no incriminating photographs or video on Mr. Banks's phone. That is true, but ultimately does not matter because it's not an element of the crime of voyeurism that you have to have taking of photographs or videos. Simply spying or eavesdropping on somebody is sufficient to sustain a voyeurism charge. So it doesn't matter whether he took photographs or video of this young girl or not. Absolutely, he had sufficient time to delete any photos or videos if he did take any, and so I don't think there's much stock in the fact that none were found in any event. The facts are that H.E., the victim, testified that, first of all, Mr. Banks did follow her around the dressing room. I would clarify that. She starts out in the second dressing room down, and Mr. Banks is right across from her in the second one down, in the stall across. She, I believe, sees that there's some clothes and some items in that dressing room, and she wants to move to one where there's not all that clutter. So I think she moves to the third one down, and Mr. Banks follows her to the third one down, right across from her. So he absolutely is following her. And then...
Was it in the record whether these were unisex or whether it was male, female?
It really was not.
I'm just amazed that nobody...
As I was reading it, I was just assuming that these were unisex because nobody raised anything when they were both in there together in the first place. But I don't think the target employee was paying much attention as this was getting started. So that may not be the case either. But that really never did come out in the record, I don't believe. But the fact is, she looks up and she sees a forearm high over the stall across from her is holding a phone with the camera pointed towards her.
Let me ask you this. I don't know if this came out in cross-examination or whatever, but if you hold the camera and you want to take a picture of yourself or view yourself, wouldn't the camera be facing outwardly?
Well, actually, these new phones have cameras on both sides, so you can actually...
So do we know what kind of phone this was, whether it did or it did not?
I do not recall, Your Honor. But again, I think the fact of whether photographs were actually taken is actually irrelevant.
I'm not getting at. I'm getting at his argument that he was merely trying to view himself from behind. And to see how the garment was,
And that to me doesn't seem to make much sense. I mean, if you've got mirrors in a dressing room, the idea that you need a phone also to do that, I think if you kind of use common sense, and then why would the phone need to be that high up? I mean, it just, to me...
You've not changed in dressing rooms very much. We can only go by what's in the record, but I think that is maybe more of a common thing nowadays, that people do try to take pictures of themselves from behind to see how things look and how it, maybe not be too low in the back or whatever. But anyway, regardless, we can only go by what's in the record.
Correct. So when the victim sees all this, she's so startled by all this that she actually slides under the dressing room door so that she's not detected by Mr. Banks. Goes and gets a target employee and says, "Hey, this person is doing this," and she's very scared at this point. He walks out and she points him out, and that's when Mr. Banks just takes off running through the Target store, all the way through the store, and goes out actually through the cart doors in the middle. So this is not normal behavior by any stretch of the imagination. Then as he's running to his truck out in the parking lot, he's taking off his shirt as he's running out in public and through this parking lot. Then he scrunches up the shirt in between the trailer hitch and puts it, and that's how he wedges it over the license plate. So these are all not actions that you would, it's things you would call the actions of an innocent man that he does immediately after being pointed out. In terms of the being for the purpose of sexually arousing or gratifying himself, I think the case law is very instructive here when you look at the various appellate courts and how they've tackled this issue. They've held that the sexual arousal or gratification element can actually be inferred when there's no innocent or non-sexual explanation for the offender's conduct. So you don't need all this physical evidence and so forth and those kind of things to infer that. In some cases, one that comes to mind is somebody having a mirror in a bathroom, putting it under a stall, using it that way, similar to what we have Mr. Banks doing here. No non-sexual or innocent explanation for that conduct readily comes to mind. And that is the case here as well, where you can infer that just based on the conduct. I think all the circumstances, again, belie the explanation that he was just looking at himself. You have to look at the entire conduct, what happens before and what happens after. The following her around the dressing room. Then, obviously, the bizarre behavior that happens afterwards, the running. Why would he be running if he did not believe that he had done something wrong or committed a crime? I think it's interesting that immediately after Mr. Banks was pulled over, he stated for the reason why he ran, and this changed at trial, but initially he states that he was scared because he had an OVI on his record. Well, why would he be scared if he didn't think an official investigation was in progress or that he had done something wrong, like commit voyeurism? Why would he say that? Why would he have any reason to be scared at the scene? Now, at trial, of course, he changes this and says he went into some PTSD-like trance state, that this wasn't really him. His story changed. The victim's story never changed. And that goes to manifest weight again, and why the victim was more credible.
Counsel, I know there's not a lot of time, and I'm very interested in the second assignment of error. I'm wondering if you planning on addressing that?
The other acts evidence aspect, sure.
I understand it's a plain error argument, but
It is, because this was not objected to below. And this really has to do with the pornography was one. There was a past charge, I believe, of fleeing and eluding. First of all, I would say on the plain error aspect of this, the term plain error was used in Banks' brief, but there was no plain error argument made. And as this court has said many times, it will not construct a plain error argument on an appellant's behalf. There's no explanation of why this is obvious error or why it changed the outcome of the trial.
Did Mr. Banks testify?
Correct.
He did.
And that's my next point. He testified, and he opened the door to this evidence, first of all. He brought in his own character evidence. His explanation, of course, is this: that I was in this PTSD-induced trance. And he not only talks about that, he
But you're not allowed to use other acts to show that he acted in conformity with his character, right?
And this evidence was not for that purpose, Your Honor. It was for, under 404B, when you look at the pornography, it went to Banks's modus operandi, it went to his motive, it went to his intent, it went to the absence of mistake or accident. I think when you look at the fleeing and eluding charge, that goes more to the tampering. I think it goes again to the modus operandi, Banks's intent when it comes to evading law enforcement.
So because he's done it in the past, he's doing it again?
No.
Kind of goes to-
It's to prove intent. But in terms of the character evidence, I'd just like to expand upon that a little bit about what he brought out and how he opened the door to this kind of evidence. It's actually rebuttal evidence by the state as well. He talked about his 2 tours of duty in Iraq. He talked about working with special needs children. He talked about dealing with his son's cancer, all to bolster his PTSD story and to bolster his character. These things had nothing to do with what he was being charged with. This was pure character evidence that he was introducing on himself to garner sympathy with the judge and the jury. So the state had every right to bring out its own character evidence when that door had opened.
But that's what I'm saying. You're arguing it as a character admission, and that's my whole point. You have to show that, like you just said, that this modus operandi is somehow a scheme, a plan, intent. It's not just, you can't say, oh, well, you're arguing character, so I'll come in with prior bad acts to show you're a bad character.
Yeah, and again, that's not what happened here. This was proper 404B evidence. But at
I
the
know
same
it's
time-
not objected to, but I'm just, I'm trying to figure out how it was allowed in. That's all.
And I think those 2 reasons. I think he opens the door to some of this, and that it wasn't objectionable under 404B.
Thank you.
May I ask how much time I have?
Certainly, just over 3 minutes.
And I'm sorry, I kind of got you probably off course with your argument, so I apologize.
And I would just mention again in terms of impairing its availability as evidence, we talked about that too, or you did with Mr. Spears, in terms of the tampering. I would just point out that 2 people proved that this actually did impair the investigation. Ms. Bruning at Target, the Target employee, testified that she tried to get Mr. Banks' license plate number. As he's running out the cart door, she follows him. She's out in the parking lot watching this vehicle, but she's trying to get a license plate number like any reasonable person would, and she can't because it's been covered up by Mr. Banks' shirt. And then you have a former police officer who begins following Mr. Banks in his truck, and he's looking at trying to get the license plate too and trying to relay it to authorities, but he can't because that license plate is covered up by Mr. Banks' shirt. So he impairs it really for 2 people who were trying to relay this license plate, and the license plate never does get relayed to law enforcement. He does end up getting pulled over, that's true, and that's lucky that he eventually was found. And I think and that brings me to another point, that the case law makes clear that it doesn't matter whether the defendant is actually successful in his concealment, in his tampering. Just the fact that he ultimately is caught and what he does isn't successful does not matter. So the fact that he's pulled over 2 minutes, 5 minutes later, however many minutes it is, he still committed this crime. Just in terms of the criminal Rule 14 issue, and that it was a motion to separate the voyeurism and tampering charges for trial, and that was properly denied. And I would also bring up the standard of review here. It's abuse of discretion, and not only that, but Banks would have to affirmatively show that he was prejudiced by this decision. He can do neither here. Juries are believed to be capable of segregating proof between 2 charges when the evidence is simple and distinct, which it certainly is here. Banks doesn't really explain how the jury was going to be confused between a voyeurism and a tampering charge. And under Criminal Rule 8, actually, these two charges were ideal to be joined and tried together. They occurred at the same time and place, within seconds of each other. They were part of a common scheme. They were part of a common course of criminal conduct. These were ideal cases to be joined together. You needed evidence of one to fully understand the other. In fact, it would have prejudiced the state for these to not have been tried together. You need them together to fully understand all of the facts. And there's also this argument about, well, I would not have testified in a voyeurism trial, but I would have testified in a tampering trial. I would submit that this is really self-serving and has no evidentiary or legal significance when Banks says this. He's asking this court to basically engage in speculation as to what he would or would not have done. There's simply no way of knowing what he might have done in these various situations. The fact is that the cases were ideal for joinder.
And counsel, I need to inform you that you've utilized 15 minutes today. Thank you.
Thank you, Your Honor. I would just respectfully request that this court confirm the judgment of the trial court. Thank you.
There are 5 minutes remaining.
Thank you, Your Honor. Quickly, as to the suggestion on the manifest weight argument, there was no innocent explanation. He actually testified to what the explanation for his conduct was with the phone. So we would submit that, Mr. Banks would submit that there was an innocent explanation for that, one of which he provided. In regards to the other acts, the issue there was it was very difficult to understand what the purpose of the introduction of the testimony concerning the porn, and that his wife disapproved of porn, even more so than the other 2 crimes, which were domestic violence and fleeing and eluding. The other aspect was that there didn't even seem to be any foundation or guidelines or time frame in which these things were occurred, how they went to proving a motive or any of those other things. It just seemed to have just come in, and when we're dealing with a case concerning voyeurism like this, the truth is an adult can watch pornography that includes adults and that is properly licensed by state and or federal laws where the jurisdiction is. They can do that legally. If we believe the state's position and the crimes he was ultimately convicted of, you could never partake in that conduct legally. It is always illegal to tape someone, view someone, spy on someone, take pictures of someone in a partial or complete state of nudity for the purposes of gratifying, sexually gratifying yourself. So even the introduction, I think, it just further muddies everything, because if there was a need to bring it in, I can only speculate as to what some of those needs were from the state's perspective, and that was to somehow reach at the trier of fact to suggest that there's something inherently wrong with watching. And that's exactly what these rules are intended for us to avoid, so that they don't have to consider those things, because they do not have any probative value as to proving the elements in this case. Also, too, we really don't know whether there is a sufficient temporal nexus, because we don't know when the allegations are supposed to be. It's just like sometimes in the past. Now, we obviously would have an understanding of when the other crimes actually occurred, but when it comes to the porn, we don't know that. And it just concerned, every time I looked at that, it just concerned that that came in and that was in the mind of the trier of fact, that he watched porn and it was in a manner which it was objectionable to. And I think when we hear in testimony husband, wife, child, those are highly close and special relationships. And many times the state of Ohio, and many times defense attorneys in trial, use those relationships to heighten better understanding of the defendant, better understanding of the victim. I know this person better, so if they're nice and kind and loving, and that's the testimony, it lends credibility because they have that specialized information. And to suggest that someone's wife was so upset with that conduct that they had issues or they brought it up and there was a problem with it, I just think puts a trier of fact in a horribly difficult position. And I think, honestly, that's exactly why these rules would exist. As to the joinder issue, very briefly, it just appears that, and I understand resources and different things like that, but I always suggest that there's one person in every trial that is sitting in a hot seat. And what can our laws, what can the Constitution, what can our assurances do to make sure that that person is sitting in the hot seat, regardless of what the outcome is, has due process and a fair day in court. The state attempt to get a conviction, ultimately a punishment that could result, and in this case did result in prison sentence. We should endeavor to make sure that that happens.
And counsel, regretfully, I need to inform you that you have your last remainder of your time.
We would ask the court to grant release. Thank you, Your Honor. Thank you for your attention.
Thank you both for your presentations today. The court will take the matter into advisement. We will issue a decision. It will be mailed to both sides as well as posted on the Ohio Supreme Court website.